Hey everyone, it's RobbRyder. This is going to be a relatively short video because I want to touch on things I need to touch on before I forget that I knew about them and didn't ever share the information. That would be a real shame. So basically this is about don't argue, let's audit and verify. And verify that those who consented to the jurisdiction follow the rules. So if they're governed by the rules, let's make sure they're following them. And when they're not, we'll point out the obvious errors and omissions to an Office of Internal Auditing. Because there's numerous kinds of audits, but the ones that seem to apply would be financial, compliance, or performance. And so, to illustrate the idea that needs to be tested by numerous people, I think the best thing is I'm going to tie it to your real estate stuff. Whether you have a mortgage or property taxes, you're still going to want to do this. And I think it's better for everybody, right? Because there's just a few. I mean, there are very, very few people that get off their ass and do anything. But if it means saving you some money and it makes you get off your ass, well, more the power to it. Let's go do it. So let's talk about your mortgage or property taxes. Warning, you may want to dig your papers out of the closet after this. But you should watch this first. Go get your stuff and then maybe watch it again. But hey, I need your help. In fact, I need your donation. I do all this just based on donation. You don't help me out, I got to shut her down and go get a fucking job. Excuse my French. Right? Jeepers. I guess sitting thinking about this stuff all day doesn't qualify for a living because Uncle Sam doesn't want to pay me. So anyways, if you could, the PayPal account is ashleyrytlewski@gmail.com, or you can send it by mail to Robert Rytlewski, 10955 14 Mile Road, Northeast, Rockford, Michigan, 49341, 866, not 5, 8664. What the heck is wrong with me? That's why I read these things when I do them. It's Tuesday, June 16th, 2015, and if you'd stop just for a second and write that information down, beep, we can continue. Let's talk about receivership just for a second. See the definition below. I ran out of paper. From Wikipedia. In law, receivership is the situation in which an institution or enterprise is being held by a receiver, a person placed in custodial responsibility for the property of others, including tangible and intangible assets and rights. And rights, not intangibles. Your rights are intangibles. Assets, I guess those would be your privileges. But whatever they are, right, they're intangible. They're just, they don't really have any substance. Although they mean everything, right? They're not made out of dirt. Especially in cases where the company cannot meet its financial obligation or enters bankruptcy. And bankruptcy is definitely different than insolvency. Let's continue on. The receivership remedy is an equitable remedy that emerged in the English Chancery Courts. Well, then it's equity, that's for sure. It has nothing to do there's nothing to do with money damages here. Where receivers were appointed to protect real property. Receiverships are also a remedy of last resort in litigation involving the conduct of executive agencies that fail to comply with constitutional or statutory obligations to populations that rely on those agencies for their basic human rights. Let me read that again. Receiverships are also a remedy of last resort in litigation involving the conduct of executive agencies that fail to comply with constitutional or statutory obligations to populations that rely on those agencies for their basic human rights. There are several types of receiver appointments. Appointed by government regulator, privately appointed receiver, court-appointed receiver. All sorts of them. All right, so receivership is a remedy of last resort in litigation involving the conduct of executive agencies that fail to comply with constitutional statutory obligations. Now, who could that be? Well, when you understand that an attorney and counselor at law, I guess is the proper term, attorney and counselor at law, by taking a voluntary oath became a civil officer, well, they're in the executive agency now. They're under the Attorney General. And because of that, well, if they're not following their oath, constitutional or statutory obligations, such as they don't sign papers in their proper name and so forth and so on, you need to go to receivership. Ask for it. So if you're in foreclosure, motion for the appointment of a receiver. Receivership in foreclosure is a receivership in an action for a foreclosure of a mortgage or lien. It is producing or proceeding in aid of an action for the foreclosure of a mortgage on real estate wherein a receiver is appointed. The receiver will be appointed to take possession of the mortgage property, which is just the paper, not your house, it's the paper. Pay the expenses of the receivership, insurance, taxes, accounts for the surplus proceeds, and turn them over to the court for application to the mortgage debt, if not required, for satisfaction thereof, to the mortgagor. And see, this is what happens. When you go into bankruptcy, you're not insolvent, you just haven't paid your debts. If you go into foreclosure, you're not insolvent necessarily, you just haven't paid your debts. That's what they're saying, so go pay the debt. Now, the question is, what's the real debt? Is it the number they keep telling you you owe? Or is it the $10 debt that's in the, when you read a warranty deed where it says for $10, another valuable consideration, blah, 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 blah. Well, who gave the dude $10? Apparently you owe him $10. And I believe already what's happening, because there's things happen in the background you never see in the court. The court you're in isn't a court of a political subdivision, because you got to wrap your head around this. If the government went bankrupt, then none of them entities exist anymore. And the evidence is in the fact, just go see if they have a properly a valid oath and oath of office and official bond, like it says they're supposed to have in your Constitution and laws and so forth, and they don't. Well, then they're not holding the office, right? Not that office, so they're not in a government office, right? So you may need to go to. So to me, the judge sitting in the courtroom is acting as a receiver. He has the property. Or the chief judge of the county is the receiver, and they have the property. And these other minions are, out there trying to have been delegated receivership powers, and as they sit in the courtroom, they're in control of the property. But that was all set up by the plaintiff behind the scenes, and you don't know that you're in this private hearing. You're not in a public hearing, you're in a private receivership hearing. And you need to ask for a receiver. That's what it looks like to me. I mean, somebody should try it just to see what they say. If you don't like what it is, kick their ass out. But if you're in foreclosure and you're fighting for every last thing, motion for a receiver to be appointed. But there's more to it than that, so let's go on. So this is the idea of, reading what they're supposed to do, finding the errors in what they're doing, and then finding somebody to point it out to. But you can't take it to court, because that isn't where you take it to. They're all in the executive branch, and there is no judicial branch, because the judicial branch was shut down because we went into receivership. And so we got to find the receivers. Another name for them could be auditors. Could be internal auditors. A lot of things it could be. But I'm going to show you some examples. So bear with me. Let's go over here. So here's one of these pieces of paper that I didn't know existed, and if you can find yours, I think you'd be really, really happy. This is from Roe, and in her paperwork for, the closing on her house, there's an affidavit of title. And it says, the undersigned affiants, being first duly sworn on oath, say, and also covenant with and warrant to the grantees, right, Roe and her husband, the affiants have an interest in the premises, which is the land and buildings. That's what premises is, a very particular word, described below, or in the proceeds thereof, are the grantors. In the deed dated 7/11, I think that is, 03, to the grantees conveying the following described premises. All right, so this next part, this lot 162 of unit, that's the legal title. Right? Anything else is not correct. And what you're going to see real soon, I'm going to show you some paperwork where they're only using portions of this. And the smaller portion they use, the larger jurisdiction you're going to be in, and the more taxing districts you would be part of. And so you want to make sure that, well, you know, that there's something that shows that you're the owner of this, right down to Kane County, Illinois, and, you know, they may stop at Kane County, not have any Illinois. Well, you just, you know, you're no longer in Kansas. Anyways, it's an affidavit sworn to, right? The problem with this piece of paper is, that I can see, is it's never been filed anywhere. You having an affidavit in your drawer doesn't do you a damn bit of good. It needs to be recorded in the public record, and where that is yet to be determined, to my satisfaction. But I'm going to say in Roe's case, it's the circuit court, because they're the ones that are supposed to have all the records for property. They're the ones making the determination over there in the court whose property it is. So you need to give them an affidavit and say, well, I got an affidavit of title. I was never given the title, but I got an affidavit said that this is my property and it is my title. All right, so again, on some of these you're going to see that all they did is they didn't put Illinois. But for instance, let's look at a tax bill. This tax bill, what are they using, right? Property location, 1903 Rita Avenue, St. Charles. Not St. Charles, Illinois, right? St. Charles. It's not in the state of Illinois. But they're sending it to last name, first name. Now, both of these used to be last name, first name, both lines in Roe's case, and she made him go and change it, but they refused to change the top one. And they can't. 1903 Rita Avenue, St. Charles, Ill. Right? Well, that isn't, again, that's an assumed mailing address. Somebody may have given that address to somebody, and it doesn't necessarily mean it's the proper address, it's just one they're using. But all this is done by a guy named David J. Rickert, Kane County Treasurer. Well, is he now? Right? Because if David J. Rickert, Kane County Treasurer, is who he says he is, then he needs to be a licensed CPA. And in the state of Illinois, there is no David J. Rickert, Certified Public Accountant. Okay. And he's doing it for this thing called a parcel number, right? So he's basing this bill on a parcel number, which is a 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 digit number. Well, as it turns out, they're just forgetting to put the last 4 digits on this parcel number as part of their scheme to steal your property. And let's see what we got here. Okay, I want to have that one open. Give me a second. I want to get all these things open I want. All right, now here's Roe's property card down at the Township Hall. All right, they got the deed and the last name again, which is incorrect. They got this PIN number, which is, it's a PDF plus PIN, it says. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. That one's got 16. The other one had 10. Here's what they say the legal. They don't say it's the legal description. They just say the legal. All right? Does that look anything like 162 of Unit Number 6, Cambridge? Nope. All right, so they're not. It's just by error and omission. That I don't know what jurisdiction that is, but it's a different jurisdiction than this thing is. That's just pretty much obvious, right? So everything, because this is the premise, and the premise includes the fixtures and the land, you know, if you want to say what your legal description is, then this is the legal description that you'd want to use. It takes you right down to your piece of your lot. And it looks like it was properly done. So, okay. And on this card here, it Again, they're not using the right one. Let's see what they got. What else they got? Map area, certified, don't have no route. See, I think this route is the mailing route. I don't know what it means, to be quite honest, but what is the route? Could be a route. Right, that should actually be your mailing address by the map. But we don't need that to do what we're doing. I'm just yakking because I point at things and I like to say I think it could be that and then go see if it is or not. What do we got here? Lump sum amount, recording, date. So I don't know if these go across like this, like they're supposed to. This original one was never recorded. All right, there was nothing recorded on 9/1/86. We got our date here, but it's like everything is running. I don't know why this one is up here. It's like it was put in late. It's a late recording. It was actually 6/1/1986. Finally put in 2001, which would make sense if they're staying one person behind as far as who the owner is. And those are things I've talked about in the past. And again, we don't need to get too much into it. I'm just pointing out there's all sorts of crazy things that we should be looking at on these pieces of paper. And we're touching on a few of them. And but let's get a little more in detail. So parcel index number is kind of what we're talking about. This thing called a PIN. All right, and that's a parcel number. Didn't say it's a PIN number, but it is a parcel number. Your parcel index number is now required on your Illinois state income tax. You can find your parcel number, didn't say parcel index number, said parcel number, on your tax bill. And sure enough, there's the parcel number. But it didn't say it's the parcel index number, just the parcel number. But they're talking about a parcel index number, so we should make sure we know what a parcel index number is. Also known as the permanent real estate index number is a numerical code for the legal description of a piece of, get this, land, as it has been defined for the purposes of real estate taxation. How to find your PIN? The best source of your PIN is your deed, not your warranty deed, your title deed, or your tax bill. Right? Because you want the deed that shows you own the property, not that somebody's selling it to you. A warranty deed is really just it's a contract. It's an agreement between you and the grantor, if you're the grantee, to purchase the property, but it's not the title deed. The title deed's with the title company. Or it's with the bank, and the title company is acting as their agent. Local state bank. So we have the local state land trust. But the best source, right, deed or tax bill, or other document you may have purchased from home. If you don't know, call the county assessor's website, or can help you locate. If you go there, can help you locate the PIN for an address. Matches are not guaranteed, and these may be some addresses not available. In most cases, the assessor's office provides a photograph of the property, which can help verify the match of the address to the PIN. Okay, so this PIN is very important because it is a numerical code for the legal description, which would have been what we saw in the affidavit. Verify the PIN with a legal description on your deed to confirm you have identified the correct property. Right? So if you're in Cook County, you could just go copy this off the Cook County's website, which is where I got it from. David Orr, Cook County Clerk, right? All about PINs, property index number. I don't know what they call it that everywhere, but that's what's called in Illinois. And, right, how to read a PIN. The PIN is what is it? 14-digit number, composed of a 10-digit base that is modified for condominiums and leaseholds by adding a 4-digit unit suffix. The basic PIN structure is AA, SS, BBB, PPP, right? Area, subarea, block, parcel. U, the unit number for condominiums and leaseholds. Zeros in this portion of the PIN indicate non-condo, non-leasehold PINs. But you need to put the zeros down. And otherwise, it's just the parcel number. This should be -0000 if what they're saying is what do you use 0000 for? Zeros in this portion of the PIN indicate non-condo, non-leasehold. In other words, you're the owner. Apparently, you want to have zeros where the U's go. However, there's a chance there may not be zeros where the U goes. And on this property index card, because I had the PIN number in there, so looking at what we started at with, now they've added two numbers, right? So let's just go back and look and see what they started with on the tax bill. It starts with 09. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Well, they still didn't get it quite right. All right, so I don't know what the 005 is. That's the PDF, I guess, whatever that is. But this PIN number doesn't match. It's not complete. It's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. It needs one more zero to be complete. Otherwise, it's considered a leasehold. Or, whatever the other word was I used. Zeros in this portion of the PIN and all the U's indicate non-condo, non-leasehold PINs. So if you don't have all zeros on your tax bill, right, then this is incorrect. And so that's part of the problem. Go down and tell the treasurer, hey, you're using the wrong parcel number. Right? Somebody is not using the right number somewhere. But because all the land never left the township, I'm going to say this is where we really need to get, this thing needs another zero. They've made a mistake in this number, this PDF plus PIN, and it needs to be corrected. And if it was, that would change your status as far as your ownership of this property in the jurisdiction where the land is, which is the surveyed township, surveyed back as part of the Northwest Ordinance. The land never left. They've just put other maps on top of it. Okay, so there's an example. Again, I'm not. This isn't completely to the depth I might wish I could tell you because I got so many other things to do. But I do want to point this out. Okay, now that's that. Now let's look at something else. We're going to look at this thing called a form. Fannie Mae Form 1003. It's a loan application form designed by Freddie Mae and Freddie Mac that is used by lenders to obtain financial personal information the borrowers who apply for a mortgage loan secured by a 1 to 4 unit residential real estate. So what is it? It's the loan app. The Form 1003 is filled at 2 times during the loan process. So you're going to do 2 applications for a loan. Isn't that just wonderful? Let's not just get 1, let's get 2. Form first, completed at time of making loan application, and this form is generally referred to as the initial. The initial helps establish the date of application, permissible purposes for obtaining credit, report, yada, yada, yada. The initial may be completed by the borrower or by the loan originator on behalf of the borrower. However, the initial should be signed by each borrower. Right? So if you don't sign it, apparently, well, then, yeah, it wouldn't have any value, would it? You can't say that I wanted it unless I signed it for it. For applications taken over the phone, the originator may complete the application, send it completed to the borrower for signature. Okay, so do you have a Form 1003 and did you sign it? Well, if you applied for a loan, it would be in the bunch of papers in the box under the bed for all the papers for the house. You should be able to find it. So the second Form 1003 is prepared at the time of loan closing. This is generally referred to as the final and prepared by the lender. The lender, the lender, the lender. The lender. Remember that, the lender. The purpose of Final 1003 is to have a borrower confirm the loan application information after all the details have been verified by the lender. This is the person that's supposed to have lent you the money. He'll be on the Form 1003. Let's find out if anybody lent us any money by seeing that the Form 1003 has been completed. And forget the deed of trust and the mortgage and the note. Show me the loan application that's been verified by the lender. Which means the lender would have to sign the damn thing. It's the only way he can verify it. Multiple borrowers. Another Form 1003 is prepared at time of loan closing. So, there's some shenanigans going on with this, and I'm not going to read into all this stuff, but right, it's just that Fannie and Freddie, they require this. The design of the form meets various regulations, right? So if you don't use this form, use something else, well, you're violating all these regulations. And, okay, so we got an idea of what that is. Now, let's look at one, shall we? Uniform Residential Loan Application. It's also called a Form 65, by the way. And as we look at our piece of paper, you will see the legal description here stops where? Kane County, and there ain't no Illinois. And just again, so we have it to look at, right here it's Kane County, Illinois. But that ain't what that says. It says Kane County. But the title's going to be, right, so they got the names in the right direction. They're not backwards. We looked at something that said the deed was in the name the other way. Who the heck was that? Where was that? Property card, I think, right? Right, deed. Ass backwards here at the top. Here, the title, so the deed, right, is going to be put in the names the proper way. How? In fee simple. Well, fee simple means you don't owe anybody anything. And then, then the rest of this form just gets into your particulars, right? But see, it says Freddie Mac 65, Fannie Mae 1003. Okay, now. Sorry about this. I got a 15-year-old computer with XP, and not everything is working quite the way it should because they don't support XP anymore. Go figure. So where are the records at? Damn it, I put your ass over here. Which one did I want to get? Okay. This is page 2, right? This is just more personal information that is of no interest to us. But page 3. Page 3. Hey, the borrower didn't sign. Not only did the borrower sign, neither did whoever this person is, right? The interviewer. To be completed, face-to-face interview, right? No signature. This never happened. It's like, they planned on having a meeting and nobody showed up. In fact, this damn form doesn't have any dates on it any place. right? The interviewer's employer. Now, it doesn't say that this is the lender. It just says this is the employer, Mid-America Bank. But again, there are no signatures. Now, like Rose said, this isn't the original. She doesn't know. They didn't sign it. But I'm just saying, well, what they gave you for your copy shows you didn't sign it. So let's bring it up. Make them bring in the one that's signed. And then there is this thing called a continuation page, right, where they list some other things that, which in itself, this whole thing is about the form is interesting, but I can't spend a lot of time going into it, other than to say that I actually have one here. This is the way the form looks today. I'm hoping, right? And first of all, there should be boxes that are checked at the top, right? Borrower, co-borrower, yada, 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 goes through 1, 2, 3. And then they got this continuation sheet page. Borrower, co-borrower, loan originator's signature, loan originator's name, loan originator's identifier, loan originator's company, loan originator's company address, loan originator's company's name, right? But where does it ever say who the lender is? And then let's say that they do. Now, if you go look for Stearns Bank National Association to see if they have a certificate of good standing, if this is your state, and you find, well, there's no Stearns Bank National Association, but there is a Stearns Bank N.A. N.A. They're not the same entity. Right? Stearns Bank National Association, as you see it in that block, if they want to be the bank, have got to be registered and approved by the state to be a bank within the state. And if they don't, they can't do business. And they're not, because there is no Stearns. Is that Stearns? S-T-A? Stearns Bank? Stearns Bank? I can't fucking read it. S-T-A-R-N-S, Stearns Bank, right? Apparently there's no Stearns Bank National Association, but there is a N.A. Right, so you, if you have one of these, if you had a loan, you ought to have one of these pieces of paper and go look at it, see if anybody signed it, see if you signed it. Start making that the deal, especially if you're in a foreclosure, and take it to put in a motion to have a receiver for this to be handled in receivership for the reasons stated before in the definition from Wikipedia on receivership. Take that in and show the judge. And saying that nobody signed the damn papers. I never got a loan. But they did take my note, which is a negotiable instrument, and converted it into Federal Reserve notes by depositing it in a bank as a check. And since they never gave me a loan, I'd like to have my property back. I'll take it in Federal Reserve notes. That's fine. Just leave it the way it is. All right, the note was extinguished. It doesn't exist anymore. Now it's Federal Reserve notes. They converted it for you. Okay. Now, what they did do, though, is at some point they did send Roe a commitment letter. Loan information. Automatic payment plan option is available with this loan. Funds condition. Fully executed gift letter from eligible donor and evidence that the gift funds have been received. Satisfaction. Roe's a little bit different because of the way she bought the property. Yours doesn't need to say that, but, yada, yada, yada. What the loans, what it said was, they gave them a loan number and a date and an address, but not the legal description, for a commitment to loan them $160,000, right? Provided these conditions had been met. Right, all these conditions, which, that's not an authorized signature, is it? I don't believe it is, but it doesn't matter. It just means they've been met. But what we read was that a final 1003, Form 1003, needs to be done at the closing. And so I don't care what this says. You need to show me the application, the loan application, that shows that somebody signed a piece of paper. And that would be, page 3 or 4 now. It depends on what year you have. But the borrower didn't sign it. Neither did the co-borrower. It didn't happen. There never was a loan. And this is a simulated legal process using color of law to seize my property, which is a violation of my private rights. Right? For the record, I'm a national of the United States. I don't consent to the jurisdiction of your private court. Is this a private or public hearing? Interesting things you might say to a judge, just to see what he says. I know people, but I might get in trouble. Now, let's go even a little bit further. Let's look at some maps. All right, so the maps that you get from your county or city or whatever right now, they're not completed. They're not the final plat. And until it's the final plat, it's not the final plat. Well, what does it take to become a final plat? Well, it takes a lot of certificates. Shall we count them? 1, owner's certificate. 2, you want to know who the owner is? Find who signed that thing. Notary certificate. 3, county clerk certificate. 4, certificate as to special assessments. 5, county engineer certificate. 6, plan commission certificate. 7, director of public works. 8, city council certificate. 9, special flood hazard certificate. 10, mortgagee certificate. 11, every plat has to have 11 certificates attached to it in St. Charles, Illinois, for it to be considered a final plat. And until you see the final plat, it ain't done. And your job is to get that plat finalized, because they haven't completed the job. And this is, what do you mean? Now, what am I going to do? Well, you're going to point out that here is the requirements of the city, and the city doesn't have a plat that shows these requirements. Then there's obviously a problem in the performance of the offices that are supposed to make this done. And I think we need to audit their performance, audit their, or else I shouldn't use performance. It's the other one. Starts with a C. We'll go back and find it here. Financial compliance. Audit their compliance. Tell them you want everything audited, right? We don't want a financial audit where they're just looking at the numbers on the frickin' paper to see if the numbers add up, right? We want them to go look at the piece of paper the number came from to make sure that it's been done properly. And whether that's compliance or performance, I'm going to leave it up to the inspector to let the frickin' person who's being audited decide. So here's, this is more likely what they may give you is, all right, so here's a portion for rows, and it has a few of these, right? Here's a couple of them, right? But row had the whole picture, and they don't have 11 different certificates on it, but they do have some. So they would be on the piece of paper, they would be on the map. And on this particular one, if you look, here's all the lots. None of these lots have access to the road. And the road doesn't have access to wherever this goes to. Right? Because not all the maps have ever been updated. And if this is what they're using as their basis to determine your status, they're saying you don't have authorization from your lot to be into the road. You don't have a driveway in to cross the right-of-way. close some of these up. Let's see. So where is that at? Right. Well, the right-of-way is right here. View, rotate, clockwise. All right. This is an incorrect name, I believe. It's not a plat of survey. It's a survey of a plat. But again, they like to do that, right? Of lot 162, unit 6. I don't know if this is exactly proper or not. It doesn't say it's the legal description, but it looks like they're talking about the legal description. And I didn't compare it to this affidavit, right? Because I'm going to go with, well, this is what the guy gave me. He swore to it. This right here. Lot 162 of unit 6. Right? And this says unit number 6. There you go. And this says unit NO6. They're not the same. I think there's other ones now that I remember. But you can see right here by the map that it's showing. It doesn't say driveway, which is a word. It just says drive, asphalt drive, with a right-of-way being the walk, and it's split, and you don't have permission to cross the right-of-way. Even though that's your property, right? You own out here to the center of this road. That's all your property. This public utility is supposed to be over here on this side, not here in your private property. But you can look at what they did with Rose property. They put her in a box. Right? She's living in a box. She doesn't have access to the outside world. If she crosses into the right-of-way without having a permit to be in the right-of-way, well, then she could get a ticket by the right-of-way police, which is under the Department of Transportation. And so this is a whole other thing about this right-of-way and how we're supposed to have you don't want a driver's license, but you do want to have a permit to be on the right-of-way, because the right-of-way on which the road lays is made up of private property of adjacent landowners that gave an easement to put the road in, but it's still their property. And not everybody owns property, but the road needs to be available to everybody and maintained by everybody, so they want you to get a permit to pay your $15 a year or whatever it is to, maintain the roads. But it isn't through the DMV or whatever they tell you to go to. It's more like through the Department of Treasury. And in fact, I'll show you not Department of Treasury, the Department of Transportation. I'm going to show you here just a second. Okay, switching gears from property just a second to go to transportation. This is from the Arizona State Legislature. And if you went to definitions, it would tell you that, where does it say? Department means the Department of Transportation acting directly through its duly authorized officers and agents, and the director means the director of the Department of Transportation. So within this Act, we're going to be talking about the Department of Transportation. Why is that important? Because if you go down to AR, or 28, ARS, Arizona Revised Statute, jeepers, this long thing, 2001. It gives these definitions for things. And one of them is, I got to find the thing that I had this all. Forgive me. This isn't going to work. I got to find something different. Okay, that's what I wanted. Okay, so department means Department of Transportation. Director means the director of the Department of Transportation. Assessor or director as county agent, except in counties that have entered into an agreement authorized by Section 2006. The assessor of each county is an agent of the department for the performance of the act's duties delegated by the assessor, or to the assessor. So the assessor is a state employee under the Department of Transportation who is supposed to be the one that is executing this law. Now, it's just lowercase county assessor. Who is it? Well, here the assessors are in the township. So is that who it is? Because lowercase county, that's just a jurisdiction. In the Federal Trade Commission, in the definitions of what the definition of a state, where it gives all the things you would normally think, then it says any political subdivision of a state is a state. Right? So to be called a county it's just somebody in a political subdivision holding an office. The outlets and offices are constituted county offices of the department, right? Of the state office. If they may be in the county, but they're state offices. It's the local administrative branch of the state office, and there's lots of people that would say that the Department of Transportation, that's the receiver in bankruptcy. Or they're at least, they're doing part of it. Now, if there's one of these things, the department assumes all powers, duties, and responsibilities of the county assessor pursuant to this title. So if they don't use a county assessor, then the department's going to take the power and they're going to put their own person in. But I want to get down to this. 2003, fees. Right? So these are fees that you would pay to the Department of Transportation for each certificate of title. All right, salvage, a title, restored, those are all different. For each certificate of title, by itself, $4. You want a certificate of title for your car? It's a $4 charge. Except when it's provided in 28117 for motor vehicles, right, to register your motor vehicle is $8. 4 and 8. We spent $12 so far. We got a certificate of title and we got a registration. Duplicate registration card, $4 more. And, something like this. So, for the registration of a trailer or of a semi-trailer that exceeds 10,000 pounds, a one-time fee of $245. That's all it should ever cost you to ever register your semi-trailer. For each identification plate bearing a serial or identification number to be affixed to any vehicle, $5. Didn't call it a license plate, it's identification plate. Bearing a serial or identification number, similar maybe to your registration number. And that's the plate, whatever it is, doesn't matter if that one or not. Whatever this one is, what is the one that's going to be on your car, and I bet you that the frickin' cops don't stop you. It's going to cost you $5. I'm sorry, right? You're going to have to join some frickin' society. You can't have anarchy. Do you want to pay $5 and have a plate and have them leave you alone? Do you want to pay $4, have your car certified? Do you want to pay $8 and have it registered and just be done with it? Well, then you need to go to the Department of Transportation, not the DMV, not the Secretary of State, although it could be called that someplace else. In Arizona, it's the Department of Transportation. And as it turns out, if you get a traffic ticket in Arizona, they have a thing called abstracted judgment. I don't remember the exact dates, but I did a video on it some time ago. That's why I know all this stuff. It said that the abstracted judgment is supposed to be sent to the Department of Treasury within X number of days. I think it was 10 days, certified by the clerk of the court. And they list the things that are supposed to be on the form. Well, Bobby in Arizona, back when we had found this a year or so ago, called the Department of Transportation. They said, well, we don't have it. You're going to have to call the court to get one. And so he called the court. They said, yeah, come down and give you one. And he went down there and they printed something off the computer, signed it, and handed it to him. And, all this was supposed to have been done on the day of the ticket, basically, not the day he's there getting it. And it doesn't have all the information that's required by the law and. So, if they don't let you do this, they're not following their procedures. This is my point, right? And Bobby is pointing out a case to them now that they're not following their procedures because this abstracted judgment isn't with the Department of Treasury. Okay, so we pointed out all sorts of things that you could complain about, and that is the proper thing to do. But what are we going to do about it? Or who are you going to complain to? I don't know if we're there yet or not. We're getting close. I'm going to shut this off and clear my windows. Give me just a second. Okay, so an idea of what you might do, and as soon as I find it, we're looking for somebody to audit the performance of these people not following these laws, procedures, rules. I'm not going to say like the criminal code so much, and even so much the statutes or so forth, although we may bring them up. It's the rules they're supposed to follow, because this is all administrative. The sovereign state went bankrupt, and now there's a receiver, and we need to go to the receiver for a remedy. And I believe that when they say receiver, they're talking about an auditor. Right? And so here's a form for Kane County auditor. So what's this guy do? Well, he audits Kane County. When you read about the Kane County auditor, he's there to do internal audits. And of course, yearly they do financial audits, but they're just looking at the numbers in the boxes. Nobody ever comes to them and say audits their, let's audit their performance. Well, here's where you can. Right? Please check which box best describes relationship. Resident doesn't say that you're a citizen of the county, although they tried to tell Roe that she was before. Not this office, but somebody else. So you could do that, but you could pick whatever one you wanted. Which best fits you. Please check all relevant boxes that best describe. Theft of cash or county assets, abuse of personal use county resources, fictitious supplies, false invoicing, kickbacks, under or over billing, payroll fraud, falsification of records. Well, that may be, then put the zeros on your form. That'd be a falsification of a record. It's a 14-digit number. It's only got 10 on there. What's going on? Under and over billing. If you understand that when you get pulled over for a ticket, they're going to make you sign a piece of paper that's going to become a bond, a instrument of indebtedness. And or for whatever reason they might stop you. So Roe got stopped for disorderly conduct because she was trying to get the recorder to give her information. The recorder didn't want to, and explain why she's paying $45 for a $6 frickin' certificate like the law says. And so the recorder said she was disorderly and called the sheriff, and the rest is history. $35 fine, but when they take you away to that private holding cell, before they let you go, they make you sign a piece of paper. They like to call it the certificate of defendant. And when you go to court, they're going to point their finger at that signature you put on and say, is this your signature? But when you read what it says that you are agreeing that you are now indebted to somebody for $1,500 or whatever they put for the bond amount. Well, a disorderly conduct is a Class C misdemeanor, of which only has a $120 cash bail, and if you don't show up to your hearing, they're just going to keep your whole bail. Otherwise, they're going to keep going to take the $35 for the fine, throw something else on, but it can't be more than $125, and no jail time. Yet, because you don't show up to the hearing, now because they didn't tell you where the hearing was, they didn't give you the right address, because they don't have your right address, they are going to say you didn't appear, and now it's contempt of court. And now, they can hang that over your head for the rest of your life. They can hold you civil contempt of court. They can hold you in jail as long as they want to. And it's all because you didn't show up for a $35 fine, which you'd already paid by paper. But because of the way they filled the paper out, it wasn't shown that way. So you might take it to this guy who's the Kane County auditor, because it's the Kane County courts that did it to you. So, you fill this little part out, and then you do the who, what, when, where, and why. And I was just playing with it to see how much room you had, right? So, but in a nutshell, officers and employees of Kane County engaging in antitrust activity, tax evasion, false impersonation of public officers have usurped the coercive powers of the political subdivision, the County of Kane, State of Illinois. These individuals do not have proper certificates of election, appointment, or oaths of office or official bonds. Kane County does not have an EIN issued by the Internal Revenue Service, and no IRS determination letter ruling acknowledging the claim status of County of Kane, EIN, whatever, exist. So basically, if you go to Kane County, that's what the sign says, and you sign like a copy of your W-9, they give you one that has on there the County of Kane. And they like to say it's a government entity, and this is why we're, this is why we're exempt, and we're the government. See, we got W-9 says we're a government entity. And that's why nonprofits like to say, well, we're nonprofit. See, we filled out the paperwork to be a nonprofit. But what they didn't get is the IRS determination letter ruling that they are who they say they are. And of course, they never want to get it. The idea is to never send anything to IRS anyways. It never leaves the county box. It's just all antitrust. You're not in a state court. State courts don't exist. State went bankrupt. Right? Somebody wouldn't pay the bills. In Michigan, in the township statutes, it says if you don't, only the qualified registered electors can vote to tell the treasurer of the township to pay the bills. Now, if they don't vote and he don't pay the bills, they're going to put the municipality into foreclosure. Well, into bankruptcy. Not because it couldn't pay, because it wouldn't pay. But who's the government in the township? The people are. And so you, as the government of the township, had just been put into bankruptcy because you weren't a registered elector qualified to tell the frickin' township treasurer to pay the bills. Well, that's all happened now. Now we need to go to the receiver to get a remedy. And that's why I believe this guy is. So, by error and omission, on record, simulated legal process, color law, crimes against humanity, Kane County conspirators participate in the enslavement of mankind. I just like to throw it on really thick. The affidavit of title upon which I am grantee stands as truth as to the premise I own in fee simple. Please audit the books, correct the records, and see to my complete remedy and equity. And so we're pointing out to the auditor, look, I have an affidavit that says this is the frickin' property description, legal property description, and it's not on the records, and they won't fix them, and I'm upset, and I want you to make them fix them. Right? So, and you had a little bit more. Right? Can you provide specific documentation to support your allegation? Yeah, I got the frickin' affidavit of title. Okay, simple one-page form. Just send it in and see what they do. Now, Bobby was told, so what Bob did is he called somebody in Arizona. I don't remember who it would have been. I think he found something to do with auditing in the state, and he said, is this the department that does internal audits on performance audits on other state agencies? And they either called him back, I think he got a message because, the phone tag type stuff, where they said, yes, Bobby, we are the office that does that, but there's a particular way to do it, and here's A, B, or C to do it. One of those A, B, or C's was to go see these people here, the Arizona Ombudsman Citizens Aid, and to file a complaint with them. Well, how do you do that? Well, you follow the directions. And so what Bob was going to do, first he decided to go to the director of the Department of Transportation one more time, but to go here to this ombudsman and say, look, the law says if you get a ticket, copy of the abstracted judgment is supposed to be with the Department of Transportation. They don't have it, or they won't give it to me. I'd like you to get it from them. But if they don't have it, it means the court didn't send it. And I'd like you to go find out why the court didn't send it. But what you're going to find out is you're going to find out it wasn't done properly, and that these agencies need to be audited because it's not just me, it's everybody. They handle the same way. And we need to have a compliance performance audit by going to the Arizona Ombudsman. So he did find the office. I said, yes, we are the one that does. But to have it done, you got to follow a couple simple steps. And so we'll see where all this goes, but it's kind of where we are today. And I wanted to especially share the part about you need to go if you're in a foreclosure or you got taxes or whatever to do with property. They're not, your PIN number they're giving you isn't, or your parcel number isn't the complete number. And it's not done properly, and your, to me, it just looks like it starts with the property card in the township for sure, because this is where the property is. Right? It's in the survey township. And this legal isn't complete. It should be a long thing like we saw on the title deed. Or on the Affidavit of Title. And we're going to be pushing that stuff to see what's happening. This is where we are today, right? And if you could or would, go look your own up and ask them, what's your legal description? And a better end in the word, comma, whatever the state is, it looks like. Anything else would be a simulated legal process. Where's that? Right here. Affidavit of Title. Now here's an intro. I just noticed this. This is a different county. It's in DuPage County. That's interesting, Ro. Your property is actually registered, or was, this was done in DuPage County, not in, what county does she live in? Kane. This is the next county over. Very interesting. In the county where the property's been recorded, and they recorded this in a different county. Oh, that's just too frickin' great. One more thing to check, and we'll see what happens with that. Okay, that's what I had to tell y'all. I hope you can and will, please, donate. AshleyRatluski, gmail.com, or Robert Ratluski, 10955 14 Mile Road, Rockford, Michigan, 493418664. Thanks to those who have. I couldn't do what I do unless you had. And I'm not asking you to again, but, you know, if there's anything you get in the value of this, if you could help me out, I appreciate it. And I'll leave it at that, because I'm not going to argue. I'm going to audit and verify. I got to get back to work. See ya. Take care.